Welcome to Middle Class Matters Business News in English from Dr CMA Alagesan. Today we will see on Securities Exchange Board of India confirmatory order on Subash Chandra, the chairman, and Punit Goenka, the managing director of ZEE Entertainment Enterprises Limited. Continue. 37. Before proceeding further to deal with these submissions of the entities in this regard, I would like to summarize the fund transactions among the various companies as noted above. 37.1. ZEE Limited or its subsidiaries and or listed companies of SL Group and their subsidiaries transfer money either to or to their related party or to companies with whom they have commercial interest, in some cases long-term commercial relationship. 37.2. The recipient of the funds from the SL Group transfers the funds the next day or within few days, that is 1 to 2 days of transfers, almost identical funds to the conduit entities. 37.3. The conduit entities transfer funds within themselves the same day as they may have received it, almost identical, and the funds ultimately reach the promoter of ZEE Limited, Spirit Infra Power and Multi Ventures Private Limited, or the body corporate related to the promoter family, Charu Enterprises LLP. 37.4. Spirit Infra Power and Multi Ventures Private Limited or Charu Enterprises LLP transfer almost identical funds as received from the conduit entities to one or more of the associate entities. 37.5. Associate entities transfer exactly the same amount as received from either Spirit Infra Power and Multi Ventures Private Limited directly or indirectly, or Charu Enterprises Limited LLP to ZEE Limited. 38. Thus, it can be prima facie seen that the SL Group, where the entities and their family members or an integral part have an overwhelming presence in the fund transactions, be it the source of funds or as part of layers through which the funds have moved, or be it the immediate transfer of funds to the associate entities just prior to the later transferring funds to ZEE Limited. 39. It is submitted by the entities that the bank statements by themselves can never lead to a conclusion that transfer of money is pursuant to a sham transaction or on account of circuitous transactions as alleged in the interim order. I agree with the submission of the entities to the extent that per se, the entries in the bank statements cannot lead to a conclusion that they are pursuant to a sham transaction or part of a circular movement of funds. The same is also not the prima facie observation of the interim order. An entry in the bank statement shows that a particular transaction has taken place in the bank account of the holder. It is only when the digital footprint of the said transaction is traced along with the attending circumstances and the entities involved in the transactions, one can determine whether it was part of a circular transaction or not. The interim order has also examined the digital footprint of a particular transaction along with the various entities involved in the transaction, which had prima facie shown that an identical sum of money has moved through multiple layers within a span of few days before finding its way to the bank account of one of the associate entities prior to being transferred to ZEE Limited, which was one of the initial source of the said funds to begin with. Therefore, to submit that interim order has relied upon the bank statements independent of other circumstances of the instant matter is an incorrect reading of the interim order. 40. Entity number 2 has made the following submissions with respect to the fund transfers. 40.1. If the very first bank transfer was for a bona fide business transaction and for due consideration, the remaining entries appearing in each instance are of no consequence, more so when no loss has been caused to Z Limited. 40.2. All the transactions are backed by proper documentation, including the transactions with the related parties or approved by the audit committee. 40.3. As long as Z Limited has made payments towards valuable consideration, subsequent utilization of funds by other parties to repay Z Limited do not constitute diversion of funds. 40.4. With respect to related parties, it may be noted that entity number 2 was not in control of their day-to-day transactions. Further, entity number 2 cannot be asked to explain the transactions beyond the first instant and those with whom he is not connected with. Moreover, he has not benefited from the impunged transactions. 40.5. There are instances where the money received from Z Limited is either more or less than the funds that were allegedly circulated. 40.6. Entity number 2 has taken appropriate steps and put in measures and checks in place to ensure that the allegations as made in the interim order cannot be repeated in future. 41. Before proceeding to deal with the above said submissions of entity 2, I would like to emphasize that the prima facie findings of the interim order is that the funds have moved through the several layers and in a circular fashion to reach the account of the associate entities who transferred it to Z Limited. I have already noted above a common pattern in the fund transfers among the companies and or body corporates involved in the fund transfers. The said commonality across multiple chains of fund transfers during the same period, wherein most of the transfers, transferors and transferees are prima facie connected at this stage on a preponderance of probability basis, cannot be ruled out as a coincidence. Therefore, as noted in the prima facie order, as in the interim order, in order to show that Z Limited has received money from its 6 associate entities equivalent to the fixed deposit amount which was liquidated by S Bank Limited towards the dues of the 6 associate entities, a prima facie scheme was orchestrated and to that end the impunged fund transactions took place. Thus, as all the legs of the fund transfers were pursuant to the prima facie scheme, they have to be seen together to have a holistic understanding of the fund movement and in conjunction with the attending circumstances. Without prejudice to the above, I proceed to deal with the submissions of entity number 2 in Sritium. 41.1. With respect to the submission of entity 2, that if the first transfer is for a due consideration, the remaining entries in the transactions is of no consequence. I note that the same would be prima facie contrary to the facts and circumstances of the case. To state that the first leg of the fund movement is an independent and distinct transaction from the rest of the fund transfers would be seeing each fund transfers in isolation. The prima finding of the interim order is that the prima facie a scheme was employed wherein circular fund transfers have taken place to show receipt of funds by Z Limited from the associate entities. Towards that end objective, the various parts of the scheme were designed. As noted in the preceding paragraphs, the associate entities did not have funds equivalent to the amount that was appropriated by S Bank Limited by liquidating Z Limited's fixed deposit of INR 200 crore. Neither the companies that were used as conduit entities or for layering the transactions at the requisite funds. The same necessitated infusion of funds. Thus, the need arose from Z Limited or its subsidiaries or subsidiary of listed companies belonging to SL Group to initiate the initial transaction which kick-started the whole circular transaction. It has been noted in the preceding paragraphs that the entire set of transactions were completed within a few days, and at each stage or leg of the scheme, the funds had moved immediately upon receipt of the same by the transferee. Moreover, the companies belonging to SL Group were present both at the time of inception of the transaction as well as towards at the end part of the transaction. In the preceding paragraphs, a common pattern that has emerged upon examination of bank statements of associate entities and constituent entities have been discussed. The said common pattern raises significant red flags with respect to the fund transfers. To brush the pattern aside as mere coincidence would be incorrect, as it happened at the time when the associate entities were in dire need of funds to return to ZEE Limited. Furthermore, there are multiple constituent entities that are common across the fund transactions and are ultimately transferring the funds to either one of the promoters of ZEE Limited or to a body corporate which is closely connected with the entities. Therefore, the submission that once the first leg of transfer is explained, there is no need to explain the rest is untenable, as there are a philanthropy of circumstances that are inextricably linked with the fund transactions that prima facie enabled the associate entities to transfer funds to ZEE Limited, and the same cannot be accepted as genuine. Therefore, at this stage of the proceedings, I am unable to agree with the submission of entity number 2, 41.2. With respect to the submission of entity to number 2, that the transactions are backed by necessary documentation and approval of audit committee, it is noted that the following documents have been submitted by him. 41.2.1 Agreements with Living Entertainment Enterprises Private Limited, SL Business Excellence Services Private Limited, Pen India Limited, and Coiris Communications Private Limited. 41.2.2.3 Credit Notes issued by Pen India Limited. 41.2.3 Entity number 2 has not submitted any documents with respect to fund transfer done by Zee Akash News Private Limited and Dish Infra Services Private Limited, stating that he does not have access to their records. 41.2.3.1 With respect to the agreements with Living Entertainment Enterprises Private Limited and SL Business Excellence Services Private Limited, it is observed that they are related parties of ZEE Limited, and both the entities have a long-standing commercial relationship with ZEE Limited. There is no surprise that audit committee approvals are in place for transacting with them. However, submitting an agreement and stating that the fund transfer was pursuant to that does not carry weight. No material has been brought on record to demonstrate that the impunged fund transfer was pursuant to the agreements. What was the value of services that was offered during the relevant period? When was the invoice raised? Commonality of processes followed during the previous instances of delivery of similar services, etc. Therefore, at this stage, given the linkages between the entities, the circumstances surrounding the timing of the transfers, and the large number of similar sets of circular transactions, I am at this stage unable to accept the submission of entity number 2 that the fund transfers were genuine in nature. Please like the video, subscribe to the channel, please share to your friends and relatives so that they will also get educated how the companies do manipulations in the transactions. If we are investing in equity funds or in debt funds of these companies, how we will get affected will be explained in the remaining portion of this. Thank you for watching.